Hey everyone, welcome to another edition of Polite Society News. This is the Legal Friday edition, and joining me, as he does almost every Legal Friday, is Alex Ooley from the Forge of Freedom podcast. Alex, thanks for coming along for the ride today, man.
Hey, great to be with you, Paul. Thanks for having me.
Absolutely. Got really just two topics I want to talk about today, two news stories that hit my radar. First one, this one, we may go a little bit on this one. The first one, Chicago judge rules statute barring felons from having guns unconstitutional under the Bruin decision. I'm going to read a little bit at the beginning of the article here. A Chicago judge recently ruled in the case of a felon convicted multiple times that the statute barring felons from possessing handguns is unconstitutional. The federal case was thrown out of U.S. District Court Robert Judge Gellerman by U.S. District Court Judge Robert Gettleman earlier this month. The felon was facing a mandatory minimum 15-year sentence if convicted of being in possession of a firearm. Then I'm gonna jump down deeper in the article here. The ruling goes beyond even the Illinois State Rifle Association, a staunch defender of the Second Amendment. Even the ISRA believes there are exceptions to those rights. Quote, I'm opposed to criminals who have been charged with violent crimes and convicted of those violent crimes from getting a handgun or FOID card or concealed permit of any kind, said Richard Pearson, executive director of ISRA. The potential consequences of the case are significant, especially in Chicago, where there are a huge number of felon in possession cases. The ruling goes beyond even the Illinois State Rifle Association. Anyway, I think I got there was a double pace there. But anyway, I want to take a little bit of exception here to ISRA's standpoint, and that is this. If all you can get somebody is felon in possession charge, you need to do better police work. You need to find another crime. Every person, if they've got a heartbeat, they've got a right to defend themselves. In my opinion, they've got a right to defend themselves with the best tool available. They have the right to defend their country with the best tool available. And look, you made a mistake. Who knows? We all change. I'm not the same person I was 10 years ago when I started Polite Society podcast. I'm certainly not the same person that I am when I graduated high school. It is 37 years now ago that I graduated high school. I'm not the same person I was then. You cannot just I'm against lifetime bans for any reason. And this is just it just seems to be junk. From the legal side, there is a federal statute that says felons can't possess. What's your opinion here, Alex?
Yeah, well, I agree with you, Paul. It seems like the Illinois State Rifle Association here was the win was too big for their liking. They seemed a bit surprised that the win was such a big win here. But you're right. This statute, federal statute, 18 USC 922. G, and we've been talking about G, or at least lots of people in Second Amendment media have been talking about this subsection G a lot with respect to subsection G8, of course, because of the Rahimi case, which provides a prohibition for those subject to a domestic violence restraining order. But this particular case was challenging 18 USC 922 G1, which says that it shall be unlawful for any person who has been convicted in any court of a crime punishable by imprisonment for a term exceeding 1 year. So it's not technically a ban on felons in possession. It doesn't say anything about a felony, but it says who has been convicted in any court of a crime punishable by imprisonment for a term exceeding 1 year. So even if you were not, in fact, punished with a sentence of a year or more, if the crime itself could have been punishable by more than a year, then you are forever dispossessed of your right to keep and bear arms, which I think is unconstitutional. As we've talked about before, I think all federal restrictions on the right to keep and bear arms are unconstitutional. unfortunately, even though we've had good case law coming from the Supreme Court, it's not as good or as pure as I would like it. Nevertheless, this case is interesting because there's been a lot of talk about the Range case out of the Third Circuit, the Brian Range case, which involves someone else who is challenging Brian Range, challenging this same statute, 18 USC 922 G1, but he was convicted of a non-violent felony. This person out of the Seventh Circuit, I'm blanking on his name, I think it was Glenn Prince. He had been convicted of violent crimes, and that's not really discussed in the opinion. The judge basically addresses it as if it doesn't matter. It's all felonies. It's whether or not this 18 USC 922 G1 is constitutional on its face, no matter if it's a nonviolent felony or a violent felony. So it's a very, very strong opinion. Of course, the government is going to appeal. I think they've already filed their appeal. And I think the Seventh Circuit, as we all know, is not particularly friendly to the right to keep and bear arms. So I expect that the Seventh Circuit will overturn this decision. And this will have to be this issue of the constitutionality of 922 G1 will ultimately have to be decided by the Supreme Court, maybe in the Range case. The Range case was set for a conference with the Supreme Court today. So we should hear, it's my understanding, by Tuesday afternoon at least, whether or not the Supreme Court is going to grant review or cert of the Brian Range case.
Well, and it seems that this year the Supreme Court is amenable, to use a little bit larger of a word, to taking more Second Amendment cases. They of course have taken the Rahimi case. They've taken a, believe it or not, a First Amendment case relating to the NRA. And there was one more in the mix. I know there are three.
Case.
Yeah.
Stop. Yep.
And the Cargill case. So there are three right now that the Supreme Court has on their case for this year. How much room do they have? I mean, how many cases overall? You may not know this. How many cases overall do they take every year? It's probably 50 or 60, right?
I think it's in the neighborhood of 60. And let's face it, too, it's not unusual. And you make a good point, Paul. It's not unusual for other rights like the First Amendment, Fourth Amendment, Fifth Amendment, other constitutional rights to be reviewed by the Supreme Court in multiple cases throughout a term. So I think this is good. I think the Second Amendment, the Supreme Court should be taking more Second Amendment cases. I mean, let's face it, we didn't have really any Supreme Court litigation on the Second Amendment until Heller in 2008, and then McDonald, of course, in 2010, and Bruin in 2022. So there's very little guidance from the Supreme Court about the nuances of the Second Amendment and what the right to keep and bear arms really protects, at least in the view of the Supreme Court. So I think it's appropriate for the Supreme Court to take up more cases, especially where lower inferior courts are being so combative and resisting the guidance from the Supreme Court in Bruin.
Yeah, and that I'm as I listen to your answer, I'm becoming more and more heartened. If they're willing to take 3, 4, or possibly more cases this year, and we get the kind of guidance we got in Bruin to start with, if we get more to back that up, we could get to my dream of, in my lifetime, getting back to the Second Amendment where it really was in 1791, where I can place that order with Amazon and get that A10 delivered.
Yeah, exactly. I mean, because, and I always like to point out the work of Stephen Hallbrook. I mean, the right to keep and bear arms protects all bearable arms. So that's there's this argument about, well, should we be able to have tanks or bazookas or fighter jets, etc. Well, if it's a bearable arm, then it should be protected by the Constitution. And the federal government has no right, has no power, rather, under the Constitution to regulate or to infringe upon that right. And that's one thing that I was a little bit disappointed about. And I know that the Rahimi case has been beaten to death with people's analysis of the briefing in that case and the oral argument in that case. But there was no Article One argument made. Apparently, Rahimi had waived that argument. There was no due process argument made. Apparently, he'd waived that argument as well. And those are some of the strongest arguments that he could have made. So I'm hopeful that even if the Supreme Court rules in favor of the government and against Rahimi, that at least they'll leave open the possibility of those challenges going forward for other people. So when we have a better plaintiff to challenge these unconstitutional federal statutes.
Yeah. And yeah, it's somewhat difficult to get a really good example of somebody that's convicted of a crime punishable by 1 year or more in prison that is on the side of advocacy and wants to fight this going forward. I'm sure there are some. I mean, looking at numbers, people that have, I don't know, been convicted of tax fraud or other felonies that may still be okay in looking at it looking at it through the public's eye to go forward. I mean, let's face it. I don't think. Oh, what is her name? That lady that went. She was a big TV star. She was a. She's
Martha Stewart.
Martha Stewart, yeah, she's a felon. You don't see Martha Stewart going to fight for her Second Amendment rights, although she would be an ideal candidate because she was convicted of lying to the FBI, and that's it.
Well, I think the Brian Range case, I'm hopeful that the Supreme Court will take that one up because I think that's a great case for the Supreme Court to start moving down that path, to start carving out the nuances of the Bruin test, and then also, what sorts of people are included in the people within the meaning of the Second Amendment. Because as we all know, the Second Amendment says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And so that's the question here. Are felons part of the people within the meaning of the Second Amendment? And I think clearly they are, with respect to, they don't lose their right to free speech. They don't lose their right to be free from unreasonable search or seizure under the Fourth Amendment. I think that we know from Bruin, the Second Amendment is not a second-class right. So why should we treat the right to keep and bear arms for felons differently than we do for these other rights? Now, of course, if they are serving their time, then they don't have that right. But once their time is done, that's a different story.
Well, absolutely. I'm nobody's arguing you should give prison inmates Second Amendment, the ability to exercise Second Amendment rights. Nobody, I think, anywhere is arguing that. But look, if you've done your time, if you paid your debt to society, you ought to be able to become a fully functioning member of society. I want to get to this comment quick. Excuse me. Robert says there's another district court opinion from Pennsylvania ruled that a denial of 2A rights for a drunk driving conviction, third offense, punishable by 3 years imprisonment, was unconstitutional. And he followed up with, that's a state felony, but non-violent. There's another example of one, and I've talked about that one on the air. I can't remember if it's you and I that talked about it, Alex, or if maybe it just came up during another discussion. But another example of a non-violent felon winning, and I'm hoping winning a lot more like this going forward.
Yeah, and one thing that concerns me about the Rahimi case, of course, we know that if the proposed government regulation burdens the right to keep and bear arms, and there's a showing that it it implicates the text, then the burden shifts to the government to show that there's a history of firearms regulation that is analogous to the current proposed government regulation. And so the question is, how close does that analogy have to be? And of course, during the Rahimi oral argument, there was a lot of discussion about, well, there's a history. The government argued there's a history of prohibiting people who are not responsible from keeping and bearing arms. And that sort of devolved into an argument about, well, it's really not people who are not responsible, it's people who are dangerous. But I'm still worried that the analogy or the uh, breadth of the analogy that the Supreme Court is going toward or seemed to be going toward during oral argument is going to be broad. So, is somebody who is convicted of drunk driving, for instance, a danger? Are they a dangerous person? And are they going to fall within this sort of dangerousness conversation uh, that was going on during the Rahimi oral argument? And I don't know what's the scope of this dangerousness analysis going to be. And I'm concerned that it's going to be more broad than I think it should be, and more broad than the Constitution, I think, allows.
Absolutely. And one thing that bothers me about this whole uh, felons and prohibiting possession of firearms, they are, and then again they aren't, because if you own a firearm that was, I believe, manufactured before 1892 or somewhere in that area, the government doesn't consider. Yeah,
Yeah.
government doesn't consider that a firearm, and yeah, I mean, this is it's just not realistic. Firearms themselves, if taken care of properly, can last much longer than a human lifetime. Uh, there are working examples of matchlocks, original matchlocks. There are working examples of flintlocks, which are a little more recent, that are all original, maybe just have one or two parts reconstructed. This you setting a date of when it becomes a firearm, it doesn't make much sense to me, man.
Yeah, oh, absolutely. I think it's arbitrary. I think that, um, you, like I said, all federal firearms regulation I think is unconstitutional. So that includes obviously the National Firearms Act of 1934, the Gun Control Act of 1968, 86, et cetera. So a lot of these are just line drawing that I think is mostly arbitrary. For instance, why does it matter? Uh, we talk about the length of a barrel on a short barrel rifle or a short barrel shotgun. Again, we're not talking about years here like we were with your example, but we're just talking about a matter of a few inches difference, and
Yeah.
suddenly they become more dangerous and they need to be registered with the federal government. I think that's clearly unconstitutional, serves no purpose, and it's completely arbitrary.
Um, yeah, a 16-inch barrel is legal, 15.5, and you're going away for 5 years. Yeah, exactly. Um, Larry over on the Facebook side has a comment. Florida, he says, extends this to BB and pellet guns. I think that's meaning felons cannot possess BB or pellet guns. Uh, I wonder if that's just not because BB and pellet guns look like the real thing and can be used to perform robberies because they look like the real thing.
Yeah, I don't know. I'm not familiar with this particular law from Florida, uh, but I'd be interested to see what that law says. Obviously, in Indiana, that wouldn't even be considered a firearm if it's got a projectile that's propelled by compressed air. That's not considered a firearm. It has to
Mm-hmm.
be propelled. The projectile has to be propelled by means of explosion. So it's this, there's a fine distinction there, and I'd be interested to know what the grounds for the Florida law or the nuances of the Florida law are.
Well, we've got about 10 minutes left. I do want to get to our second story I wanted to bring up with you. And this one, Mike Piwowarski and I discussed this briefly on Wednesday. We were running out of time as we did it, but federal judge declares no right to acquire a gun. This is a bearing arms. Doggone it. A bearing arms story by Cam Edwards. U.S. District Judge John L. Kane, an 86-year-old appointee of Jimmy Carter. I was surprised to know there were any Jimmy Carter appointees still on the bench, but appointed in 1977, made this eyebrow-raising decision in a case known as Rocky Mountain Gun Owners versus Paulus, which challenges Colorado's newly enacted 3-day waiting period on all gun sales. Kane denied the group's request for an injunction that would have halted enforcement of the waiting period while the litigation continues, ruling the plain text of the Second Amendment only covers the right to keep and bear a firearm, not to purchase or acquire one for lawful purposes. And this is one excerpt from the judge's ruling. From the reading of this plain text, it is clear that relevant conduct impacted by the waiting period, the receipt of a paid-for firearm without delay, is not covered. Still, plaintiffs attempt to equate words obtain and possess, but these terms are not equivalent to keep under the definitions provided in Heller. Meant to retain an object one already possessed. It did not mean to receive a newly paid-for item, and it certainly did not mean to receive that item without delay. Likewise, having weapons indicates that weapons are already in one's possession, not that one is receiving them. I know you disagree with the judge. I disagree with the judge. Alex, this is just wordplay, right?
Yeah, and frankly, this judge, I think he is feigning some constitutional analysis here, but there is no constitutional analysis here whatsoever. If you look at the Second Amendment, of course, in isolation, it doesn't say anything about the right to acquire a firearm. Obviously, it talks about the right to keep and bear arms, and that's what he hangs his hat on. But I think it's important to step back here and look at why the Bill of Rights was adopted, because at the time of the founding, the Constitution was proposed as a replacement for the Articles of Confederation to form a more centralized form of government, because they were worried that the Articles of Confederation would lead to a country in disarray. And of course, the anti-federalists at the time were concerned of a more powerful centralized form of government, because they had just won a war against a very powerful centralized government in the form of Great Britain. And so the Bill of Rights was adopted to protect certain individual rights from government infringement. And the Federalists were like, in this argument, they basically said, listen, we don't even need the Bill of Rights, because the Constitution is a constitution of specific, limited, enumerated powers. And there is no power in this Constitution at all that says the federal government has the right to regulate your right to keep and bear arms at all. And that includes your right to keep and possess and bear those arms, but also your right to purchase or transact in those arms. There is no power within the Constitution whatsoever for the federal government to do that. So this argument from the judge just completely misses the entire point of the Constitution and the Bill of Rights. The federal government has no power to do this to begin with.
Absolutely. 110% agree. As you were talking, my thoughts after my medical challenges a few years ago do tend to wander a bit. And as you were explaining that and talking about that, my thoughts went to, well, if the government has the power to do that, I've always been somewhat of a prepper. I keep backstocks of ammunition for calibers I don't even own, firearms that fire at this point, simply because should something happen in the future, let's face it, ammunition could become a very potent form of currency or barter. And if you're not, allowed to acquire a firearm going forward, there's no distinction between acquiring a firearm or acquiring ammunition. So therefore, the government could just shut down all of our ability to purchase ammo, and that effectively kills our Second Amendment rights as well.
Yeah, exactly. And we've seen that there's been some legislation proposed by Elizabeth Warren to restrict the ability to sell and purchase ammunition. And of course, firearms are useless without the ammunition. And again, I go back to Stephen Hallbrook here, of course, about what constitutes arms. And I think that definition of arms, and this was discussed by the Supreme Court as well, includes things like attachments, ammunition, things that allow the tool to be used. Because it's not about the tool, really, the Second Amendment. It's about the right to self-defense, to protect yourself, the right to avail yourself of self-ownership and protect your interest in your property, in your own life. And these are just tools, the firearm, the ammunition, the attachments, the accessories, etc. These are just tools as an extension of that right to self-defense.
One more comment I want to get to. Larry on the Facebook side says, comments on the recent circuit court ruling excluding ARs from the Second Amendment. I hadn't heard of that, Alex. I did a specific search for legal court, the legal stories surrounding the Second Amendment for the past 2 weeks. That didn't hit my radar today at all.
Well, there's the assault weapons case that where they basically said that the AR-15 is close enough to an M16 that it doesn't fit within the definition or fit within the protection of the Second Amendment. And I'm blanking on the name of the case, but of course, we obviously disagree with the court about their ruling. The court basically said because it looks like an M16.
I do remember that.
Yeah, because it looks like an M16, and because basically you can add all these attachments to it, that it makes it especially dangerous and scary, and therefore it falls outside the scope of the protection of the Second Amendment, which I think those sorts of opinions are going to be addressed by the Supreme Court. Let's face it, the AR-15 is the most popular rifle in America and clearly fits the definition of an arm that's in common use for lawful purposes. Of course, the anti-gun lobby always tries to argue that it has to be commonly used for self-defense, and I think we could still meet that burden, but that's not the burden. The burden is to show that it is an arm that is in common use for lawful purposes, and the AR-15, if anything, meets that definition, clearly meets that definition.
Absolutely does. Robert reminds me that was the Easterbrook opinion. That does sound right, that was the Easterbrook opinion from the Seventh Circuit decision here a few weeks ago.
It was the Easterbrook opinion. I just can't remember the name of the case off the top of my head.
Is saying that it looks like enough like a M16, and you can do this to it, you can do that to it. Very similar to, look, you can take a base model Mustang out of the dealership or a base model Camaro out of the dealership and turn it into, no kidding, a car that will turn a 10-second quarter mile at 180 miles an hour. Or if you really get radical with it, you can get down to where top fuelers do 4-second quarter mile runs, 4-point high, almost 5-second. But you can turn it into something that just there's no use at all for it on the street. And yet it's still a Mustang. It's still a Camaro at its base. So why don't we just outlaw Mustangs and Camaros? That's the reasoning I'm getting here.
Yeah, that's basically correct. You could draw another analogy with respect to the First Amendment. That basically our phones are assault speech devices because they allow us to speak, or these computers that allow us to speak over the internet. They allow us to say our ideas, which people might consider to be dangerous ideas, but nevertheless, they're protected forms of speech under the First Amendment. And of course, arms have evolved and improved from a technological perspective, just like means of communication. In fact, I would say that arms have advanced to a far lesser degree, at least bearable arms that are accessible to the general public have advanced to a far lesser degree than means of communication. If the founding fathers were alive today, they would be, I think, far more astounded by our means and modes of communication, by our computers, our phones, etc., than by the firearms that we have available to us to purchase.
Oh yeah, some old broken down trucker, this schmuck in South Dakota, talks to thousands of people every time he pushes the broadcast button. And I don't think the founding fathers could have ever envisioned something like that.
Yeah, they had repeating arms at the time of the founding.
Yeah,
and,
they did.
Yeah, exactly. And the other thing here too is that the common use test. We have to remember for arms bans, we look to the common use test that was from the Heller decision, and the common use test derives from this historical test of banning, or historical tradition of banning dangerous and unusual weapons. And if a firearm is in common use, if it's commonly owned by citizens for lawful purposes, then by definition, it's not unusual. So it would have to be dangerous and unusual. So even if they could prove that somehow the AR-15 were more dangerous than other bearable arms, they would also have to prove that it's also unusual, and it's clearly not.
No, not if more people have them and have one F-150 pickup trucks. It's absolutely not unusual. All right, we are out of time, man. Before we take off, if you would please plug Forge of Freedom and anything you also want to talk about today, man.
Yeah, so obviously I care deeply about the right to keep and bear arms. I think it's essential for the preservation of our liberty and our freedom. But I care more broadly about freedom in general. And the podcast is a podcast about all things related to freedom. I talk about firearms every Monday, oftentimes with my father, but Paul, for this coming Monday's episode, I'll be releasing an episode with you to talk about your podcast and your journey in the firearms world. So I'm looking forward to our conversation and to sharing that episode with our listeners. And then on Saturday mornings, I release an episode that's more broadly related to freedom. I talk about things like qualified immunity, about the Constitution, Fourth Amendment, First Amendment, about jury nullification, all sorts of topics, homesteading, first aid, tactical first aid, et cetera. So if that's something that's of interest to you, check it out. It's on YouTube, Rumble, Facebook, and on all of the most popular podcast streaming platforms.
Very cool. That is going to do it for us today. We are overtime, but thank you everybody for sticking with us. Please do come back and join me Sunday evening when we'll do our weekend review wrap-up show. We'll talk about all the Second Amendment stories of the week. And until then, everybody, thanks for watching. Again, podcast listeners, thank you for listening, and we will see you next time.